I think that this is the most enjoyable, the funnest part of a trial, both opening statement and closing argument. But there's an important distinction that you should all recognize. It's opening statement and closing argument. Statement, argument. Not opening argument and closing argument, opening statement. So let's talk about the distinction. In opening statement, you should be presenting your theory of the case. When I was arguing cases and when I listen to lawyers present now, I look for future tense. I look for statements like, you're about to hear witness X testify to these facts. You're about to hear witness B, who is an expert witness, talk about findings and conclusions based upon their expertise. I don't want to hear in opening statement argument. I don't want you to hear he's a liar or you're going to know that he's a liar. Well, that's closer actually. That's not necessarily bad. Maybe we'll talk about that in a minute. I want to hear about what you as a lawyer believe the evidence will show when the evidence is presented. So again, you will hear witness A, Mary Miller, testify that on January 27th, 1997, she was at the intersection of First and Main and she observed a car accident. You'll hear her tell you, or she will tell you, that she saw the driver of the car fall from the driver's side with a gash in her head and exclaim, I think I'm going to die. And then you'll hear her say that she went on about how she was drinking before she was driving. Basically facts about and what the witness will testify to when the witness actually testifies. It's important to understand that opening statement and closing argument at the end are not evidence. The evidence is what happens between those two efforts. Now let's talk about how that's important for you in this competition. Because remember, this is a competition. You aren't looking as a function of mock trial for a verdict. You aren't going to await a jury's decision on whether or not you've proven your case if you're the plaintiff, or that you've successfully overcome the plaintiff's theory if you're in defense. You're looking for points. So you, as a lawyer, student lawyer, want to be compelling. You want to be interesting. You don't want to stand in front of your jury with a piece of paper in your hand, arguably, and say, ladies and gentlemen of the jury, in a few minutes you will hear my witness 1 testify to these facts, and then you will hear my witness 2 testify to these facts, and then witness 3 will say something else. And then at the end of this trial, my co-counsel will ask you to find the defendant guilty. Thank you very much. You're putting me to sleep. You're not compelling. You need to think about making a compelling presentation of your case. Again, we talk about a roadmap in opening. We talk about an index to a book. We talk about insight and building excitement. So when you finish opening statement, your jury wants to hear the witnesses that you just told them they'll hear from. So I want you compelling. I want you interesting. Think about this as you might if you were going on a first date. First impressions are very important. So you want to smile. You want to emote. You want to make your jury believe that you're present and you believe in your case, that you want to be liked. Okay? You need to sell yourself. If you're on the defense side, it's okay to also talk about what the jury may not hear and remind them or tell them where you believe the evidence will not go, where you believe the prosecution or plaintiff will not or will not be able to prove in terms of the evidence in the case. Be careful, of course, to talk about it in the future tense, that you believe you'll ask the jury to watch for these inconsistencies or the deficiencies in the evidence, what they will not hear. Mock trial. You have 3 minutes. 3 minutes. That's not very long. Most lawyers can't say hello in 3 minutes, okay? When I'm in a real trial, it takes them 3 minutes to introduce themselves, to talk about just who they are and what they're all there for. 3 minutes is not much time. But as students, as high school kids, that might feel like a tremendous amount of time. But it isn't really much time. When you begin with an opening statement, make sure you introduce yourself. Say who you are. Don't say obviously where you're from, because that'll draw an objection, and it would be procedurally improper to do so. You, when you were in mock trial, you belong to a team and a number. You don't need to tell them the number. They already know your number. But tell them who you are. If you want to, as a function of the exercise, identify your co-counsel, although you probably would have already done that as a function of the introduction. But tell them who you are and why you're there. Make sure you tell them that you understand that you're the plaintiff or you're the defense. Now, this is a civil case, as I understand it this year, so you're plaintiff or defense. Introduce yourself. Make sure that you tell them right off what your theory is. Why are you all in the room? I understand this is a breach of contract action and a defamation action. So what has brought you all to this effort? You believe that you've been harmed as a plaintiff, that there's been a breach of an agreement, and there's been defamation. There's been words spoken that have harmed someone, harmed your client. Make sure that you tell your jury that that's why they're all sitting in that jury box. You want to focus your attention on your jury. Your trier is your jury. Your presiding judge is not your trier. Okay? So your focus should be on your jury. 3 minutes, watch your time, because time will go by, and you will have a timekeeper. Make sure your timekeeper, and this is kind of a bleed over to the next section, but make sure you know where your timekeeper is so you can watch your timekeeper do their work. And timekeeper, you need to be very proactive. You need to make sure you're doing the 2 minutes, the 1 minute, the 30-second, the 10-second, the stop, waving the stop, as Mrs. McAllister talked about, how important that is. Because the time will go by rather quickly. But again, an opening statement, you're outlining your story. I always tried to coach the students I was working with to come up with a theme. Now, each coach is a little different. Each attorney has a little different idea of how that should work. But I always tried to talk about a theme in opening statement. And your theme should be your idea, your thought. We've, in the past, have used quotes from famous identifiable individuals. We've used books, the title of books. You can use anything that your imagination allows to build or create a theme. State your theme. Your theme needs to be something that you establish in opening statement, that you carry through during your presentation of evidence while you're in your case in chief and evidence and defense, and that you stress at the end in closing argument. So your theme needs to be constant, consistent, and well stated early in the presentation. There's study out there in terms of trial prep or trial presentation that lawyers win their case in opening statement. That by their compelling presentation in a narrative in opening, they bring their trier, their jury, their trier of fact. Your jury is your trier of fact. And forgive me if I use terms, I'll try to stay with jury. Studies say that juries are compelled by opening statement and lawyers win cases in opening. I, as a trial judge now and a trial lawyer for years, I tend to head that direction, although I don't think it's a hard rule. It's much better, obviously, to have a compelling argument than a compelling opening statement than a weak one. And it's not just how that you have a compelling statement in terms of your presentation. That's important. You demonstrate an opening statement that you understand your case and that you feel strongly about your case, that you are an advocate. So if you stand tall and present well to your jury, then they're going to want to listen to you just by nature, and you are going to be ahead of the game when you move into your case. So do that. Stand tall, own the courtroom, and use the courtroom in opening statement. Communicate to your jury. Know your strengths and weaknesses. I'm a big guy. When I was trying cases, I would have to, and I speak fairly loudly in court, and I kind of own the room just by the fact that I'm 6'3", or used to be 6'3" when I was younger, a little shorter now that life has gone on. But I'm a big person, so I tend to own the room just by being in it. If you're a smaller person, then understand that and move closer to your trier. I can't get close to a jury box because I intimidate. So I would move back. I would move towards the middle of the well in terms of my work. If you're a smaller person, that's perfectly fine because it's who you are and how you present, not your stature. So move closer, but recognize that physical situation and move closer to your trier. If you're soft-spoken by nature, move closer to your trier. They won't be intimidated by you because you aren't intimidating physically to them. Remember, they are an entity, and you want to try to work them as an entity. Mock trial kids. Are you going to work from a script, or are you going to be off paper? Remember, if you have a piece of paper in your hand, and many do because you're new to the process, they'd like to have that crutch. That's perfectly okay to have. If you do need that crutch, try to minimize it. Try to use the podium, put it on the podium, and refer to it as necessary. I encourage you strongly to try to get off book. Try to have a general idea of where you want to go, or a specific idea of where you want to go as a function of your opening statement. And that requires discipline and work on your part. That means you sit down with your attorney coaches and your faculty every chance you get, and you go over and over and over and over your statement, your opening statement. It's a grind. There's no doubt about it. I would sit in the hallway when I was coaching with kids, and we would go over. We would start earlier in the process. I'd have the student write out an opening statement, narrative, write it out, and it was usually, when we stood up and started doing it, it started at like 10 minutes. And then we'd whittle and we'd cut and we'd edit and we'd work and we'd work and we'd grind and we'd cut. And ultimately we'd get you down to a point where the student I had worked through it so many times it became almost rote. And that's okay if that's the way it's best for you. Some students do better working off talking points. They like to take sections of thought and stand and present in that fashion. It's all okay. You know your own mind, or should, and know the best way to present. Faculty, coaches, I'd encourage your kids to have friendly competition in who gets to do openings and who gets to do closings, because I really do think it's one of the funnest parts of the process. Nobody can object, and as long as you're within the rules, you own the room. You own the well, you own the courtroom, and all eyes are on you. And it's fun. It is fun to do. So have a friendly competition. There will be some of you who are more invested in this effort than others. That's just the way the process works. Those of you who enjoy it, are excited by it, show that excitement to your faculty, to your attorneys, and tell them that you want to do openings and you want to do closings. I think, and they are different animals completely in terms of how you think about and how you present. Let's talk about closing. So you have 3 minutes. My point's here. You have 3 minutes in opening statement that you sell your theme, you state your theme, and you present a compelling position that where you believe the witnesses will take you or take the jury when you move into evidence. Mr. Giordani and others have already talked about the evidence sections and certain rules. Let's move into closing now. And it is closing argument. One of the things that mock trial doesn't do as well as real-life trial work does outline the law as it applies to the case. This is a court of law. Laws are rules. Laws are tools of analysis that you as lawyers, student lawyers, must use. In a real trial, there's a section right before closing argument where I, as the presiding judge, having made decisions on the rule of law, actually inform the jury. I read the rules of law to the jury. And they, in my courtroom, they get a package of those laws, and they're usually fairly extensive. So the jurors are all sitting there with the law in one hand, their notes from the evidence that they've heard in the other, and in closing argument, the theory is that you as the lawyer take those two independent important facts or points and bring them together in argument. So you have the law, because it's a court of law, and the facts that they've heard from the witness stand, and you argue about where both of those independent concepts, or that's not the right word, the law and the facts should take the jury as a function of decision when they deliberate the case. So as a mock trial lawyer, and knowing how that works, I want you to tell me what the law is. Because in the competition, again, we've just spent 2 hours arguing about or presenting facts. Witnesses have testified and lawyers have done their work. So that your jury is pretty aware of the facts, but they really aren't too aware of the law. And there's two important components to the law. There's how the jury should interpret the evidence and the burdens that they should meet in terms of the decisions they must make. Now, if you're in a civil case, you're a preponderance of the evidence. So that's your burden. And if you are the plaintiff, one of the first things you get up and say in closing argument is you state your burden, because the jury needs to find by a preponderance of the evidence that you have proven your case, that more likely than not you've proven your facts. And we have lawyers downtown that have a variety of different creative ways of doing that. Some of them like the scales. A preponderance of the evidence is just tipping the scales in my direction ever so slightly. It's not 51-49. It's really more like 51 point blah, blah, blah. It's just tipping the scales ever so much in my favor, and I win. And they actually get out there with their little hands and they do their scales. Some lawyers like to do that. Some lawyers like to talk about a foot race in terms of all I need to do is win by the slightest, a millimeter, or be ahead by a millimeter in your mind, and I win my case and you give me money. You, as the lawyers, look for a creative way to present that argument to your jury. So you state your burden, and then you move to your analysis of fact. If you're plaintiff, or frankly either side, you want to talk about why the witnesses, both from your perspective, your witnesses, and your opposition's witnesses, support your position. Because in your problem, I guarantee you, there will be inconsistencies from both perspectives that offer insight or offer argument or potential argument to support your side. So you move into the evidence and you apply the rules of law to that evidence. You'll have an instruction on how a jury should view the testimony of a witness, their ability to perceive and relate, their interest in the outcome of the case or not, their bias, prejudice. There's an instruction in your packet that talks about that. And you want to tell your lawyers or your jury that you know what that means. So, ladies and gentlemen, if we're going to assess a witness A in a case, understand that under the rules given to you by this court, you're allowed to look at the demeanor of the witness, the consistencies or inconsistencies in their statements, their consistencies with the forensic or physical evidence, or the inconsistencies with the expert opinions. And you want it to, so you state the law, and then you argue the facts to the law. And you have 4 minutes to do it. You also want to state the elements of the offense. So if we're talking about a breach of contract, in your packet there'll be probably one instruction that lays out what a contract is and what a breach of contract might mean. And you'll have, if it's a defamation action, same thing. They're called elements of the offense or elements of the allegation, and there'll be instructions on it. And you want to be able to tell your jury very concisely what the elements are and why you've been able to meet those, or why your witnesses and evidence support you meeting that burden and that you've met those elements. Watch your time during your presentation. If you are plaintiff, make sure under the rules of mock trial that you reserve rebuttal. The first thing your coaches should be having you do is when you stand up and introduce yourself. Good afternoon, ladies and gentlemen. My name is David Barker, and I'll be presenting closing argument for plaintiff. Your Honor, may we reserve any remaining time for rebuttal? Because if you don't, under mock trial rule, reserve rebuttal time, you can't present a rebuttal argument. And as I believe it was Mr. Craner said, could have been Mr. Diamond, you want rebuttal. You want to be able to stand up, even if it's for 3 seconds, and offer rebuttal. So make sure you reserve under rule your time for rebuttal. Try to build into your closing argument, your 4 minutes of closing argument, my advice would be approximately 30 seconds for rebuttal if you can get there. Sometimes that's very difficult to do because, again, like 3 minutes in the beginning, 4 minutes at the end is not very much time. When you present plaintiff in that opening closing, go through your facts, go through your law, bring them together, weave them together as a function of your argument, and ultimately ask your jury to conclude and side for you based upon the facts and the law. There's an old statement in trial practice. It says something to the effect of if your case as a lawyer is supported by the facts, if you have strong facts, then in closing argument you argue the facts. If you have the law on your side, if you have case law that says something that you believe supports your conclusion, then you argue the law. But there are many times in cases where you have neither the facts nor the law to support your position. And the common phrase is, if you don't have the facts of the law, you just argue. And I'm not going to finish that statement because you're all juveniles. There's a four-letter word that goes at the end of that one. But we're not going there. You just argue. Really what you want to do as lawyers is to present to your, because again, you're looking for a 10. You're looking for a score. You're not looking for $1 million. You're not looking for a defense verdict. You're looking for a score of a 10. So you get that 10 by identifying the rule of law that applies, the burden you must meet, and arguing in a compelling way why you've met that. You do it by presenting yourself in a professional manner, and you show decorum and professionalism to your trier and to your presiding judge. So look professional, act professional, stand tall. My advice would also be to go onto YouTube. If you want to see a good closing argument or a good opening statement, go onto YouTube and pull up national high school mock trial national competition. You'll see about 1,000. That's exaggeration, but there are many examples from national that you can watch, and watch them and draw insight. Final words: be true to yourself. Know your strengths and weaknesses. Play to your strengths, identify your weaknesses, and try to use them to your advantage. Again, if you're soft-spoken by nature, use the courtroom to your advantage. Bring the jury to you. Make the jury want to believe that you are the person to side with, because if that's the case, then you're going to get the 10 and the other side will not. And finally, have fun, because this is your opportunity to use your mind, tools, and talents in a manner that this could be a profession for you. And you want to explore that. And even if you don't choose to be a lawyer as you move through your life, and most students do not, the public speaking and the tools you learn here will carry you. You will be a leader as a function of, you will grow into being a leader as a function of the tools you learn in mock trial. And it will help you in business. It will help you in whatever career track you take. So take it seriously. You can get a lot out of it. But frankly, you get out of it what you put into it. So that's my presentation. Let's move into what are we doing?